Admittedly, I was a bit younger when someone took a picture of me outside the European Union a few years ago after I spoke at the EU on the legal implications of international marketing issues that could affect member countries. That said, it was a fun experience to speak in English and have my talk simultaneously translated into about a dozen other languages, including my native Swedish. That immediate translation is very cool. Happened one other time when I did executive training for the University of California, Berkeley in Mexico City. These language experts are amazing, frankly. They're about, at that particular point in time at least, he was about 3 to 5 seconds behind me in Mexico City, translating to Spanish. Amazing skills to be able to listen, translate, and not lose the place in the talk. Now, moving on to the session on legal and ethical issues in international marketing research. We are in an IMR course, so the topic of legal and ethical issues in international research will primarily connect with marketing research topics. I'm also including a bit more text and information on many of the slides in this session compared with the other sessions given the topic again, and its importance for IMR, but not what marketing research professionals maybe tackle day to day. Let's start with some basics, given that this is a marketing research class and international marketing research at that. These 4 topics provide a foundational overview of the legal and ethical considerations that researchers must manage when conducting international research, setting the stage for deeper discussion and understanding as we move into the session. Understanding legal frameworks simplistically involves familiarizing yourself with international, regional, and local laws affecting research, such as, for example, data protection regulations and consent requirements to ensure compliance across borders. Generally, ethical research practices are essential for conducting research that respects participants' privacy, ensures confidentiality, and maintains transparency and honesty in all research dealings. Navigating intellectual property rights is crucial, of course, as researchers must understand and respect these property rights, including copyright and trademark laws, particularly when disseminating research findings globally. Managing contractual obligations requires clear contractual agreements with research participants and third-party service providers. This is important to avoid legal disputes and ensure all parties understand their rights and responsibilities. This was brief, but this overview sets the stage for a deeper discussion on legal and ethical issues in international marketing research, emphasizing the importance of compliance, respect, and transparency in all research activities. We're going to have a couple of clips early on in this session. Legal and ethical issues in the marketplace often exemplify themselves as sustainability issues. This is where I'm going with this particular clip. When it comes to marketing around the world, there's a presumption of legality in the products and services offered in the marketplace, although there are myriad exceptions, of course. Sustainability has become the do good from company standpoint and perhaps a warm glow from the customer standpoint. So this clip is about being sustainable and what customers feel.
Sustainability is very much in vogue today. Almost 9 in 10 customers say that they would consider buying a product because of a company's sustainability efforts. But these same customers had no confidence in companies being sustainable for the right reasons. The end result is that customers buy sustainable products only 22% of the time, even when they say they want to. A gigantic disconnect exists between customers, companies, and countries on how to be sustainable and perhaps even why. Somehow, sustainability has become a multi-level political issue. Some Republicans argue that certain environmental restrictions hurt the country's competitiveness. Many Democrats, on the other hand, argue that we need to protect the macro environment, even if it costs shareholders. And many people think that companies engage in sustainability initiatives just for reputation management. Everyone realizes that sustainable products that are too costly will only be purchased by a limited set of customers. The flip side is that more customers will presumably buy sustainable products at a lower price as long as the quality of the product has not been compromised in order to meet the price point. Meanwhile, there's a middle-of-the-road view here. Indications are that a company can achieve satisfactory performance even when costs and/or prices increase by 27 to 72% for sustainable products.
Switching back to more legal issues and discussion that could be derived perhaps from sustainability issues, but also many other different topics as it relates to international marketing research. This may be the one slide where you can almost read along with me a little bit, or as I presented the talking points, I'm going to look at the slide like you guys are. The General Data Protection Regulation in the European Union imposes stringent data protection requirements on all entities that handle EU residents' personal data. This regulation has significant implications for data collection and privacy in marketing research. In Singapore, the Personal Data Protection Act governs the collection, use, and disclosure of personal data. It provides guidelines and obligations for organizations conducting market research to ensure data is handled appropriately. South Africa's Protection of Personal Information Act requires adequate measures to protect personal information that is collected, stored, and used within the context of marketing research. And this law ensures, of course, that data is managed securely and ethically. Data, by the way, coincidentally, is actually technically a plural term, so it should be data are, but sounds a little interesting. So we'll go with is for right now. It probably goes both ways here. Brazil's General Personal Data Protection Law regulates the processing of personal data of individuals, similar to what they do in the European Union. It emphasizes consent, rights to access, and correction, impacting research methodologies and ensuring data protection. Very brief examples, but these examples provide a broad overview of the diverse international legal landscape, some overlapping, some similar, some not so similar. And then you can check out the world systems note that I put in. I won't go through all of those different legal systems that we have in the world. Some of them overlap, but there are differences that come into play. In the more trade agreements video, this particular video, I discussed the importance of trade agreements and trade across different country borders. We have bilateral and regional trade agreements. RTAs are the regional trade agreements, obviously, in the world. These are legal agreements, so there's significant correlation between how many regional trade agreements that exist involving then more than two countries. Bilateral would be two countries. More than two countries would be the RTAs. So there's a strong correlation between how many trade agreements, regional trade agreements are in play, and the overall number of trade, or the amount of trade in, say, dollar amount, euro, and so on, that take place across country borders. For clarity, since we are stats oriented too in an IMR class, this is not a cause and effect scenario, but the correlation is important in and of itself. Let's listen in.
The first two regional trade agreements in the world were the 1958 EC Treaty, which has become known as the European Union, and the European Free Trade Association, which started in 1960. Some 60 years later, we have about 300 regional trade agreements in force. Complementing these RTAs are bilateral trade agreements between any two countries. Engaging in any form of trade agreements naturally make it easier to enter certain foreign countries. Including both RTAs and BTAs, the United States is taking part in 14 trade agreements. The countries included in these 14 agreements are Australia, Bahrain, Canada, Chile, Colombia, Costa Rica, the Dominican Republic, El Salvador, Guatemala, Honduras, Israel, Jordan, Korea, Mexico, Morocco, Nicaragua, Oman, Panama, Peru, and Singapore. The first agreement that the United States signed was with Israel in 1985, with Israel now being the 24th largest trading partner of the country, amounting to about $50 billion in annual revenue. But does the United States and other countries really need to engage in regional trade agreements? The simple and direct answer is yes. What is important to understand is that there's a correlation of 0.991 between the number of trade agreements that are active and the cumulative value of trade across country borders. The more RTAs in force, the more we trade across countries, with a pronounced trading taking place between countries in an agreement.
Now let's move back on to some legal, but more importantly, ethical dilemmas in this particular case, because they tie very well into legal issues, obviously. Let's discuss common ethical dilemmas and conflicts that may arise during international research. Each example that I have here illustrates the complex ethical landscapes that researchers must navigate in different regions, emphasizing the importance of culturally and contextually appropriate strategies to manage these dilemmas and conflicts ethically. If we talk about informed consent, we can use the European Union as an example. Informed consent in the European Union presents a dilemma in balancing the GDPR that we just talked about, those requirements with practical research needs. Obtaining explicit consent may influence participant behavior or survey outcomes. The conflict lies in ensuring that consent forms are understandable and do not deter participation due to their complexity. Cultural sensitivity in Asia is another concern. For example, research methods or questions that are normative in Western context may be considered invasive or insensitive in Asian cultures, such as direct questions about personal income or family life, as we discussed before. The conflict involves modifying research tools to respect cultural norms while still gathering necessary data for meaningful insights. And then we can take the example of privacy concerns in Africa, highlight the dilemma of conducting research in regions with high concerns about surveillance and mistrust of data collection motives, especially in politically sensitive environments. The conflict is navigating local fears and misinformation about data usage while complying with ethical research standards. Economic coercion in South America may be another one, poses a dilemma where offering incentives for participation in impoverished areas may be seen as coercion, questioning the voluntariness of consent. Are they really actually doing this out of their own voluntary consent? The conflict here is balancing the need to fairly compensate participants for their time while ensuring that consent is truly voluntary and not influenced by financial desperation. And these are dilemmas, of course, that just around the world as a sample, but by addressing these dilemmas and similar ones with culturally and contextually appropriate strategies, researchers can ethically navigate the complexity. Now, by addressing these dilemmas with culturally and contextually appropriate strategies, researchers can ethically navigate the complexities of international research. In the context of international marketing research, informed consent refers to the process by which participants are given comprehensive information about the research. It's the study, of course, its purpose, procedures, potential risks and benefits, and their rights as participants. This information must be presented in a manner that is understandable to the participants, taking into account cultural and linguistic differences. The key elements of informed consent in this context include the 5 that I have listed on the particular chart, and let's talk a little bit about those, starting with disclosure. Participants must be fully informed about the nature and purpose of the research, the procedures involved, the duration of the study, and what will be expected of them. They should also be made aware of any potential risks or benefits. In terms of comprehension, the information must be presented in a way that is clear and understandable to the participants, considering cultural, educational, and language differences. Researchers should ensure that participants fully comprehend what they are consenting to. Voluntariness, interesting word, but we're volunteering to do something by that informed consent. Here we talk about participation must be voluntary, meaning that participants should not feel coerced or pressured to take part in the research. They should be free to decline or withdraw from the study at any time without penalty. In terms of competence, participants must have the mental capacity to understand the information provided and make an informed decision. This includes ensuring that vulnerable populations and people are not exploited, of course. Documentation. Informed consent should typically be documented through a written consent form that the participant signs. In some cases, verbal consent may be appropriate, but it should still be properly recorded. Now, in international research, it is particularly important to consider the cultural context and to adapt the informed consent process to ensure that it is. This may involve translating consent forms using culturally appropriate communication methods and addressing any specific concerns that participants may have based on their cultural or societal norms. For example, in the European Union, utilize clear, straightforward language, avoiding legal jargon. The GDPR that we mentioned, the GDPR compliance requires, I should say, explicit consent demonstrated through active confirmation, not pursued by inactivity. In Asia, provide consent forms in local languages and consider cultural nuances, such as hierarchical societal structures where deference to authority may influence consent. In Africa, Engage community leaders if possible in the consent process to build trust and understanding, especially in regions with low literacy rates. Use verbal explanations and visual aids. And then in South America, include extended family or community members in the consent process where culturally appropriate and to ensure understanding and respect for local decision-making dynamics. And then in the United States, as a comparison, ensure consent forms are HIPAA compliant. You go to the doctor in the United States, talk about HIPAA compliance a lot. You probably run into that. Where that is applicable, obviously, clearly outlining how personal data will be used and stored, and emphasize voluntary participation and the right to withdraw without penalty. If possible, and for optimal impact, be sure your company's personality aligns with your targeted customers' needs and wants. That's an interesting phrase that I just discussed or talked about and set up in terms of this single panel comic again. It's not about informed consent, but rather an alignment in this particular case in values and beliefs that the mindset of the company has and the mindset that the customer has. Interestingly, it used to be that companies seldom wanted the public to know who they may support, for example, in a political election, or what positions they take on certain issues. However, that's changing for many companies. They now often take a stand and drive that point to their particular target market as a means to forge a closer link with their best customers to build loyalty. And that's a little bit different. So every company has an experienced personality. It can be boring, whimsical, or anything in between. Be sure it aligns with what your customers want and expect. And that's an interesting challenge since we're talking about legal and ethical issues. We're also talking about aligning with customers within the scope of the legal and ethical structures that we have to live by as companies. Challenges and best practices for maintaining confidentiality and privacy in international research can be just that, challenging. However, it is a critical aspect of conducting ethical and effective studies across borders. First, consider the challenges. Varied data protection laws across countries can be complex and confusing, risking non-compliance. Each country may have different regulations and standards, making it challenging to navigate and ensure adherence to all relevant laws. Technology security risks are another significant challenge. Data breaches and unauthorized access pose substantial risks, especially when handling sensitive information across multiple digital platforms and geographic locations. Ensuring the security of data in transit and at rest, as we may call it, is crucial to maintaining confidentiality. Cultural perceptions of privacy also vary widely. Diverse cultural attitudes towards privacy can affect participants' willingness to share personal information and their expectations of confidentiality. Understanding and respecting these differences is essential for gaining participants' trust. To address the challenges, several best practices can be implemented. So let's talk a little bit about those on the right side of the screen. Developing a global compliance strategy is vital. This strategy should adhere to the strictest privacy laws applicable in any of the involved jurisdictions. That would be a starting point and will make it easy for the rest of the world that you're doing research in, such as, for example, GDPR in Europe is very strict. And that ensures comprehensive data protection, because you would assume that if you go with the most strict laws that exist, that covers you pretty well. Implementing advanced security measures is another best practice. State-of-the-art security technologies and protocols, including encryption and secure data storage solutions, should be used to protect data integrity and confidentiality. Cultural adaptation of consent processes is also important. Consent forms and privacy notices should be customized to align with local languages and cultural norms, ensuring clear communication about the use of personal data and participants' rights. And there was a lot of challenges and best practices. So the key takeaway is that maintaining confidentiality and privacy in international research requires a proactive approach. Balancing legal compliance with cultural sensitivity fosters trust and ensures ethical standards, leading to more reliable and frankly respectful research outcomes. Intellectual property or IP issues in international marketing research refer to the challenges and legal considerations associated with the creation, protection, use, and management of intellectual property across different countries. These issues are critical because IP laws and enforcement vary widely around the world, as we know. which can then affect the way marketing research is conducted, the sharing of research findings as well, and the commercialization of research outcomes. So on this slide, I put together a myriad of different examples of IP issues. Let's cover each of them briefly to take a look at what they may mean for us. Protection of proprietary information. Here we're talking about ensuring that proprietary data, research methodologies, and findings are protected from unauthorized use or theft in different jurisdictions. This involves understanding and complying with the IP laws of each country where research is conducted, not just your home country as we may think at times. Patents, managing the complexities of patent laws when developing new products, technologies, or processes as part of marketing research is what we're talking about here. This includes navigating the differences in patentability criteria, application processes, and enforcement mechanisms across countries. Copyrights, here we're talking about protecting original works of authorship, such as research reports, articles, and presentations. This involves understanding how copyright laws vary by country and ensuring that research outputs are adequately protected against infringement. Trademarks, here we're talking about ensuring that brand names, logos, and other trademarks used in marketing research are protected internationally. This includes dealing with the challenges of trademark registration, potential conflicts with existing trademarks in different markets, and cross-border enforcement. Trade secrets, a little bit more intangible perhaps, but safeguarding confidential business information such as research techniques, customer lists, and marketing strategies is what we're talking about. This involves implementing appropriate measures to protect trade secrets and understanding the legal frameworks for trade secret protection in different countries. Data ownership and use, who can use the data and who owns it and so on, addressing issues related to the ownership and use of data collected during international marketing research as we might expect. This includes ensuring compliance with data protection laws, securing necessary permissions for data use, and managing cross-border data transfers. Licensing and collaboration agreements, here we're talking about structuring agreements with international partners, could be universities oftentimes, other research institutions, and third-party vendors to clearly define the ownership and use rights of IP generated through collaborative research efforts. Many times we see many different universities or many different organizations collaborating together. Who has the license and collaboration and IP and so forth. Lots of issues that could come into play. Enforcement and dispute resolution could come into play in the example I just built there. Dealing with the challenges of enforcing IP rights in foreign jurisdictions and resolving disputes that may arise is what we're talking about. This often involves navigating different legal systems, arbitration mechanisms, and cultural approaches to conflict resolution. And it's pretty clear by all the different things we went through that navigating these IP issues requires a thorough understanding of international IP laws, careful planning, and often the assistance of legal experts with experience in global IP management. Organizations of all kinds, companies, for-profit, non-for-profit, need to develop comprehensive IP strategies to protect their research investments and maintain a competitive edge in international markets. And back to Shep Hyken, our friend again, and the single panel comics. IP issues are important for the customer. Protecting their data is the most important, at least from my vantage point. So very simply, want your customers to trust you, protect their data at all costs. The Shep Hyken single panel comic couldn't be clearer. Give me your personal information. We want to spam them with useless marketing messages, or give me your customers' personal information, better up. We want to spam them with useless marketing information and messages. Do what you want to me, but I will never betray the trust of my customers. So want your customers to trust you, protect their data at all costs. I think we've seen that with lots of corporations in lots of places around the world, that has become an issue for customers in particular if it's not done right. All right, some real world examples. We sprinkle in some, but let's sprinkle in more and do so directly on this particular slide with 5 examples of Google, Amazon, Pfizer, IKEA, and HSBC again. These are real world examples of organizations that have successfully navigated legal and ethical challenges, and they're just 5. There are many that do a good job, but we're talking about legal and ethical challenges in international marketing research. They can make a good case for the legal and ethical issues in the marketplace as examples here. Each example highlights a strategic approach to addressing complex legal and ethical issues, showcasing a large multinational corporations in this particular case. And I realize that I'm using a lot of large multinational corporations instead of small and medium-sized companies, but since we're going around the world and we're talking about international marketing research, the large MNCs make for better case examples because most people know them a little bit better than the small ones. Anyway, Google complied with Europe's GDPR by adjusting data collection and processing practices across its services. This involved enhancing transparency and control for users, ensuring that they understood how their data was being used and giving them the ability to manage their privacy settings. Amazon faced varying data protection laws across different countries. To address this, they implemented standardized data protection measures worldwide, surpassing local compliance requirements in every place, which sounds great. This approach helped maintain trust and consistency in their data handling practices. Pfizer conducted global clinic trials by adhering to international ethics standards or ethical standards. This included obtaining proper consent and ensuring participant safety, aligning with both local and international regulations to maintain the integrity and safety of their research. And IKEA again, or IKEA if you will, by my English slant, IKEA integrated cultural and legal considerations into its markets research, I should say, by using local teams. These teams ensured compliance with regional data protection laws and cultural sensitivities, allowing IKEA to conduct research that was both legally sound and culturally appropriate. And then finally, HSBC navigated banking secrecy and data privacy laws by implementing a centralized compliance strategy. This strategy respected both home country and host country legal frameworks and cross-border data flows, ensuring that all data handling was compliant with the relevant regulations. Following the examples of Google, Amazon, Pfizer, IKEA, and HSBC, it's advantageous to capture that learning by more universal guidelines for developing an ethical research strategy. So we have a fair amount of content and a few different company examples. So we captured that by developing an ethical research strategy, or talking about the points that need to go into developing one of those. I think that captures it pretty nicely at this particular point. Understanding local and international laws is the first step. Researchers must thoroughly understand all relevant legal requirements and data protection laws in each country involved to ensure compliance in data collection and usage. Establishing clear consent processes is essential. Not just the consent itself, but there should be clear processes in place for establishing consent in terms of international marketing research. Develop transparent consent processes that inform participants about the purpose of the research, data usage, and their rights, including the right to withdraw, of course, at any time. This ensures that participants are fully aware of their involvement in the handling of their data. Ensuring data protection and privacy involves implementing strong data security measures such as encryption and secure data storage. Data must be accessed only by authorized personnel to maintain confidentiality and prevent data breaches. Cultural sensitivity training for all research team members is important. We've talked about that a few times. Training on cultural norms and communication styles of target research populations helps prevent cultural insensitivity and bias, ensure respectful and effective interactions. And that could become a legal, but certainly ethical issue as well. And that's why we bring it back a little bit here and there. Conducting regular ethics audits is a best practice as well. These audits review research practices and ensure ongoing compliance with both ethical standards and legal requirements throughout the project lifecycle. Transparent reporting is vital. Maintaining transparency in reporting research findings, disclose any potential conflicts of interest, and ensure that findings are reported accurately without manipulation. Those are keys to transparency here. This builds trust and credibility with stakeholders and the broader research community. And I think that by implementing these strategies, researchers can develop and conduct ethical international research projects that are legally compliant and culturally sensitive, thereby maintaining the highest standards of integrity and trust. 195 countries, I keep mentioning these numbers, so hopefully they don't change dynamically too fast, but 195 countries and 62 territories around the world. There are lots of legal and ethical issues that come into play when conducting international marketing research. Generally adopting good research practices, as we discussed in the other sessions and upcoming ones as well in this course, ensures that researchers and consultants also follow the best legal and ethical practices in international marketing research. This includes using a company's resources appropriately and effectively. So let's take a look at that. That was sort of my lead into this particular article that we have for this session also. As with all sessions, as I keep mentioning, I conclude with an article. As a reminder, as I also say all the time, for sessions 1, 3, 5, 7, and 9, we have assignments to go along with the session and article. Hopefully you've enjoyed them so far and will enjoy a little bit more in the future. For sessions 2, 4, 6, 8, and 10, again, we have only an article as a complement to the asynchronous session, plus of course being covered on the quiz that follows. So take a look at that in the upcoming ones as well. For this particular one, it's quiz oriented. So we do have an article, but take a look at it for quiz purposes more so than for any other purposes. As you will notice throughout the sessions, a lot of this focus, frankly, is on companies' resources. So that was my lead-in terms of international marketing research. And this article in the California Manager Review that we did focus on how best to use a company's resources and Slack resources more specifically. So take a look at how best to use a company's resources when we have Slack resources, what type of Slack resources are good, how can we combine Slack resources maybe for synergistic benefits for the company. Those are all different things that we're talking about in this particular article. That is a wrap, and I always start the music, so cut myself off a little bit, so I'll cut myself off quicker. Good luck with the quiz, and then check back for the next session on sampling methods in diverse international markets.